So what is anti-kickback? The federal anti-kickback statute is a criminal statute that prohibits the exchange or offer to exchange anything of value in an effort to induce or reward the referral of federal health care program business. According to the OIG, the anti-kickback statute was originally enacted in 1972 to protect patients and federal healthcare programs from fraud and abuse. Now, this doesn't mean that all beneficial arrangements have been banned. The safe harbors that have been designated by the HHS contain specific requirements that relate to those exceptions. The Patient Protection and Affordable Care Act of 2010 expanded the liability of the False Claims Act to now definitely include the anti-kickback claims as grounds for violation. Diagnostic testing seems to be an emerging and fast-growing business area, and unfortunately, Medicare fraud and abuse cases have increased as well. Physicians and medical testing laboratories are now very savvy about how to avoid the referral fee arrangement, and have implemented new practices that seem legitimate but are really not. Most commonly, payments to physicians for collecting, processing, packaging, and handling test specimens. It is to be noted that just because cash isn't involved does not mean that the services rendered are legal. For example, United States v. Grieber in 1985 was the landmark case that established that paying referring physicians to use laboratory services violated the anti-kickback statute. The case also established the premise that if even one purpose of a payment is made for referral of business, the payment is deemed to be illegal. The new ruling prohibited business transactions that were once fairly innocuous, leading to the creation of safe harbors. The takeaway? Labs need to closely scrutinize any arrangements with referring physicians. Employees are protected when disclosing concerns. The FCA contains an anti-retaliation provision that protects employees from being discharged, demoted, suspended, threatened, harassed, or in any other manner discriminated against in the terms and conditions. Moreover, the FCA provides an incentive program for employees who disclose fraud against the government. This could lead to the whistleblowing employee receiving as much as 30% of any money wrongfully obtained by the employer. It is important for both employers and employees to speak with counsel that specialize in these areas if they have any sense that they may be non-compliant. The Office of the Inspector General of the Department of Health and Human Services outlines 6 characteristics of specimen processing arrangements that may be evidence of unlawful kickbacks. Failing to act in accordance with this law can land you with a $25,000 fine and a 5-year prison term per kickback.